The Supreme Court recently made a decision in a veterans disability benefits case that is going to have a huge impact on the way the VA operates and how VA benefits are adjudicated. And the craziest thing about all this is the Supreme Court didn't even know that they were adjudicating a VA disability case. In this video, I'm going to be talking about some things that are pretty theoretical. They deal with a fairly fresh Supreme Court decision that actually upends a lot of, or could upend a lot of regulations. It could be complicated, and it probably doesn't have a direct impact on most of my viewers' claims or appeals where we stand right this moment. It could, we just don't know yet. Before I start about what's changed, I have to talk about how things were before this recent Supreme Court case, Loper Bright v. Raimondo. How does a bill become a law? How do federal agencies know what to do? What are their rules? Where do they come from? Congress passes a law, the president signs it, it becomes law, right? Well, the law is the very broad topic upon which the agencies run. Beyond that, the agencies have to write regulations that deal with how to actually implement these laws and what to do on a day-to-day basis. In order to write these regulations, they go through something called the Administrative Procedures Act, where they do something called notice and comment. They'll draft what they think the law tells the agency to do in a regulation. They will then take this regulation, they'll post it, invite comment, they'll make changes, and eventually the regulation gets adopted, and we proceed from there. And of course, this doesn't mean that there isn't litigation over the regulations, but that's basically how a regulation is made. It's got to be consistent with the law. Winding back the clock back to the early 1980s, there was a case called Chevron v. Natural Resources Defense Council. And this case was not about veterans either. It was all about air pollution. Chevron and the NRDC, the basis of this case were what does the Clean Air Act require of companies? And can the federal government write regulations to control pollutants? And the Supreme Court ultimately decided that, yeah, the agency, in this case the EPA, can write a regulation so long as it's not inconsistent with the statute. And it's actually a little bit more complicated than that because Chevron deference really has a two-part test. So when I say not inconsistent with the statute, that's not entirely the end-all be-all, but that's where we start. Chevron deference asks two simple questions. Is the statute that Congress wrote ambiguous? And if the answer is yes, we ask, does the agency's interpretation in the form of a regulation make sense? Seems simple enough, right? So this basically said, and this is where the Chevron deference phrase comes out, is that courts should defer to the agency's reasonable interpretation of a statute when they're making regulations. Now, strangely enough, this was actually the conservative view. And I'm not talking conservative versus liberal in the political sense or how we understand it today, but this was the conservative view because it was focusing on institutions and institutional power. And to some degree, it took a lot of it out of the court's hands because the court said, hey, we're going to defer to what the agencies say as long as it's reasonable. Of course, this doesn't mean that regulations were always upheld. Regulations were shot down all the time as being inconsistent with the statute and so on. Fast forward a number of years and we have Loper Bright v. Raimondo. And if you are a news junkie or you follow the Supreme Court, this one's actually pretty big. And it, quite frankly, it upended a lot of administrative law and how we practice administrative law. Loper Bright v. Raimondo is actually kind of a crazy case, also having to do with the environment and fisheries control. So like Alaskan fishermen and what they can pull out of the water during any given season. This entire lawsuit came about because the fishermen were required to pay for a monitor on their boat, so a person to watch them fish to make sure that they weren't taking more fish than they should. And I'm simplifying things. And they had to pay this person's salary. This person wasn't actually helping them out. They were just there watching to make sure that they weren't violating the law. And of course, eventually the fishermen got together and they sued. And the Supreme Court said in this most recent decision, we don't really think Chevron got it right, which is a big deal because after 40 years, the Supreme Court says, yeah, the earlier Supreme Court decision didn't make a lot of sense. So what they did was they basically said, listen, it shouldn't be the agencies deciding what the law means. It should actually be the courts. Courts are there to interpret the law, which also kind of makes sense. And this caused a lot of consternation amongst administrative lawyers. And there's a lot of talk about whether or not the federal government is going to be able to regulate in certain ways. And that's a good question. Will they be able to write regulations that for clean air protection or what qualifies as an automatic weapon, right? So again, under the firearms control law. So these are like a lot of implications here. At the end of the day, it completely changed and removed deference from the various federal agencies. So again, how does this impact veterans on a day-to-day basis? Well, it's really too early to tell. But I can tell you that folks like me and other VA disability attorneys are going to be scrutinizing regulations and trying to line them up with the statute harder than ever. And if Congress passed a law that says this is what we intend to do, then the regulation really has to comport with that statute. Is it actually changing things? I don't know. But it was referenced very recently in a case regarding special monthly compensation at the T level, SMCT. This most recent case that we saw come out not long after Loper Bright was decided. And to tell you how fresh this is, Loper Bright was included in this decision, but it had been briefed by the attorneys in this case before Loper Bright came out. So the courts literally were paying attention to new developments at the Supreme Court and incorporated it right in there. Now, I'll tell you, this doesn't go into much of an analysis of Loper Bright, but we can already start to see what's going on. And the case I'm talking about is Laska v. McDonough, and it came out in September of 2024, so not long ago at all. And it talks about special monthly compensation at the T level, or SMCT, which is for individuals who need aid in attendance or for their TBI or traumatic brain injury. Now, SMCT, when you read the statute, talks about needing aid in attendance for a TBI. Simple enough. The regulation that the VA published, however, added a requirement that they needed a higher level of care than just aid in attendance around the house. So not just somebody to cook and clean around the house and help them get dressed, but they also needed somebody who was medically trained. They needed medical care. So if they didn't have this aid in attendance, the VA reasoned the need for aid in attendance had to be so severe that if they didn't get the aid in attendance, they'd have to be in a nursing home or some sort of medical facility full-time or nearly full-time. And the court, in this case, the Court of Appeals for Veterans Claims, actually came down and said, no, that's nowhere in the statute. The statute doesn't mention that you need that higher level of care. The statute says aid in attendance for a TBI. We mean aid in attendance for a TBI. We didn't say they needed a nursing home for a TBI, just that they needed aid in attendance. Now, of course, this Laska case did not go into much detail on Loper Bright and how it changed the landscape, but they definitely threw that out there as a shot, saying, hey, Loper Bright takes into account that it's the courts that decide, not the agencies, what these statutes and regulations mean. So I think, what does this mean in the grand scheme of things in the long run? I think what this does is that Loper Bright is just going to increase scrutiny on how the VA makes regulations to comport with the statutes. And I think the court is going to get a lot more active in taking a look at these regulations and saying, that is not what Congress wrote. That is not what Congress intended. With that said, practically speaking, though, this is going to be a challenge because not just is it going to go, this is not something that when you file a supplemental claim or you file a higher level review or any of these things, it's not going to make a difference at that level. What's going to happen is that something's going to get denied on a supplemental claim or a higher level review. It's got to go to the BVA, and that's got to go to the Court of Appeals for Veterans Claims. So what I mean is, on a day-to-day basis, is this going to impact veterans? Probably not in the short term, probably in the long term. But like I said, this case, Loper Bright, is probably the most important VA disability case to come out. And I don't think the Supreme Court was even thinking about veterans when they decided it. Now, if you have a case that the VA just didn't read the evidence or didn't weigh the evidence appropriately, give us a call. Let's see what we can do to help. Until next time, take care.